Hi. So, my question would be, I just want to understand the extent to which gaming companies host third-party content, and what can we consider as them publishing their own content. And with relation to that, also, whether it's in the scope of the IT Act or these rules to regulate the content of these games through these acts. So if you're regulating them as intermediaries, you can very well go ahead and do that. But then the question would be, if you're going ahead and regulating their content, is it in the scope of this of these rules, and the extent to which they publish their own content?
So how I see it is right now, they are not going into content moderation other than illegality. Correct? So let's say they say betting and gambling laws, like child pornography, you can't do it, but that's maximum they're saying, either third party or otherwise. Correct? In terms of if you're talking about the form of the game, correct? What characters are there, what can they do, how they are depicted, correct? That content moderation, which also then also there's an issue of age rating, etc. That in India there's no standard as such. We follow other standards. So that aspect is not covered under these rules, correct? Because in that sense, then you have to approach it as a publisher, and that is something I think some other ministry, most likely MIB, will be doing. But in this case, because as the online game is defined under this, what the vision is that because it is anyway age gated for anyone above 18, correct? So that graded age rating thing or content moderation thing might not be per se needed under these rules and scope of these rules. Right? So we might have to wait for the from a publisher and a content moderation perspective for something else from a different maybe a ministry.
Your question on to what extent do these platforms own the formats of the games that they're publishing, I think that's a larger question of what is the business model. And again, different platforms have a variety of ways in which they do it, largely contractual, where either they will have in-house developers or exclusive developers who will develop games for their platform, or it'll be a much more broad-based participation by developers that, someone has this game and you can play it on my platform, etc. So that's more a question of business model and what the contractual arrangement with those developers actually is. Because to the extent a platform may say that, listen, you are developing a particular format exclusively for my platform, I will own the IP, right? It really comes down to the contract of it, the commercial arrangement, and I don't think that these amendments are infringing on that, or it's not trying to dictate that or control that in any manner. I think, like what Dhruv was saying, is that it's not even going as far as content moderation the way we've seen for online publishers, which is under a separate chapter in the intermediary rules. What these guidelines are really doing is that they're setting out a framework of what a particular format should or should not have, and as long as it is not illegal. So I think that's really as far as what these rules are trying to establish.
Sorry, one question at the back. Sorry, at the back, yeah. Can someone?
Yeah, hi.
Sorry, okay, we'll come to you after that.
Are you able to hear me?
Yes, go ahead.
Yeah, hi, I'm Manmohan from GLI. So, what we have heard from your comments, SRO will play a very important pivotal role for any company who is already there or who are coming up. So, the question is, how will government appoint the SRO? I can understand there would be multiple SRO. And who will be the part of the SRO? And what would be the qualification of the person who get appointed? There have been appoints that they will be like 3-4 point what I saw, but how will be the SRO appointed? It would be a stipulated period, or it would be like for a long period. So just wanted to have your brains on that.
This is, yeah, go ahead.
To your point, sir, on how does the SRO work or who are going to be a part of it, the rules talk of 5 different stakeholders who will be representing different issues, right? There's somebody from the gaming industry, somebody who will be nominated by the government, somebody who's a public policy professional. So to that extent, the intent also would be that the SRO has multi-stakeholder representation, so that whatever decisions they make in terms of registration or licensing comes from a diverse perspective. In terms of how the government will register or recognize an SRO, again, the rules talk to that effect. They say that if the SRO has a diverse set of members in it, they comply or they respond to responsible gaming practices and do not have conflict within its board, then then the SRO could potentially be recognized by MeitY. And that's how I think it'll pan out. In terms of the duration, I think I think it's too soon to say, like I've been saying it before. Uh, the idea would be for them to be self-sustaining and be there for the industry each time somebody new comes into the space. So I don't think that the government's intention was to have them for a short duration as a stopgap arrangement, but to be a self-sustaining entity for the space.
So another question comes to that. So they are currently like SRO in the industry. So a little bit, I'm just thinking, so there would be new SROs also coming, or the current one would get recognized, or something like that. Because as he has mentioned, that there's a lot of ambiguity on that sense that how will he get registered, a new company coming, like is there a framework like Rummy game has to be registered with this SRO, the pool game has to get registered, the Ludo game. I'm just talking on the air. So that's a very important point because there are other stakeholders, you know what I'm coming from in the industry besides the gaming companies also, who wants to do the business and all. So how their representation would be like taken to the government and all that. So some light on that.
So I think the rules are very clear that they can be more than one SROs, correct? And MeitY has kept, so they have given, let's say, what your track record is in terms of promoting responsible gaming, correct? What your track record has been generally, whether you are at arm's length distance, whether are you structuring your SRO in that it's difficult for one player to influence, correct? That MeitY will look and then recognize. So there can be more than one. It doesn't say that it can't be 3 or 4. It could be, correct? And as I said earlier also, if there's an efficient way, definitely there will be an SRO which will be more efficient than others, and everyone will start following. So that's one thing. In terms of the other stakeholders, the very idea is because it's a self-regulatory organization and there will be a lot of industry conversation before anything happens, correct? It won't be one person writing it. Everyone will have to sit and talk. And in that sense, I think the other stakeholders will also come to the conversation. They will tell, okay, fine, how do you understand, let's say, for example, I know where you're coming from. Let's say, what is a reputed body, correct? And I think there will be industry standards that will sort of be built around it. And I think that because it is industry, it's not you have to petition to the government. Have that conversation, and I think it will get reflected into the framework, whatever that SRO creates, or whatever the industry accepts as a framework.
Let me take 2-3 more questions. There are some questions that are online as well, but some of them have already been answered through some of the other questions that people asked here. But let me go there. Yeah, to the person who raised their hand first. Yeah. Just introduce yourself and then you can ask the question. Shubham, can you check? Is that on? Sorry, or maybe we can find you another mic.
Yeah, I mean, can I be heard otherwise?
Yeah, sure. Go ahead. Go ahead.
Go ahead. So hi, my name is Keshav. I'm from the MeitY Center for Legal Policy, and I have, keeping in theme of this discussion, a multi-part question, but I'll try to keep the questions as short as possible. The first question, and I think someone mentioned this earlier, but I think there's some clarity from the panel would be good, is essentially SROs can lead to cartelization of standards, right? And the rules are not clear on how do you deal with the cartelization of standards that could become prohibitive. Now, if the answer to that is trust us, it hasn't happened, so it won't happen, that's not a good faith argument. That's not a, from any legal standpoint, that's not a good faith argument. So how do you deal with SROs not leading to cartelizations? Because as I say, I'm a game developer. I'm doing it in a specific field. There are 6 different SROs in this field. One has lower standards of compliance to the other. I look at the lower standards. So then it becomes the lowest common denominator to which I am setting my hygiene standards for, right? And that sounds slightly unsafe, especially from a legal standard and a legal point of view. So in this case, how do you then prevent SROs from cartelization standards and ensuring that compliance is at the highest hygiene levels and not a constant fight for the lowest common hygiene standards to ensure that individuals are protected against terrible game developers, publishers, etc., right? The second part to this, adding to this is you mentioned, Dhruv mentioned that we follow ESRB ratings and these sort of foreign compliance standards when it comes to age gating. Given that multiple SROs could have multiple compliance issues, what stops them from changing age gating compliances? So for example, a certain SRO says, say, a shooting game must be 18 plus, while another says 13 plus is fine for this game, right? So then your age gating, because of multiple SROs, can also lead to multiple age gatings for similar published games, right? And these rules lead to fragmenting this rather than saying we should wait for publisher rules for this. With SROs, you could have that fragmented already. So then how do you prevent age gating issues with multiple SROs fighting for this lowest common compliance standard, right? And that leads to sort of the last part of this question is, see, the Ministry of Youth Affairs and Sports has a yearly licensing thing for national sporting federations. That means every year an NSF has to reapply for the license saying, we are following the compliance and that all our state units at the national level follows this. There is no such thing for SRO. So once you get it, it's permanent. Means, are they actually following compliance standards? Does the government have the right to ensure that these SROs are following certain minimum standards at least? And because there's no relicensing issue, how does the government sort of enforce sort of good practices amongst SROs, apart from the fact that, oh, we could de-license them at some point? That's setting a much higher standard for that de-licensing issue, rather than coming clear from the beginning what is expected from the SROs, what you have to maintain your license for, and you have to come back to the government to show that you're complying with government's rules for continuing your licenses, right? So this is sort of the three-part question I have.
Great. I think a well-put question. I have some thoughts on the last one, but I'm going to defer it to the panel. Anyone wants to take that? Yeah.
So I'll take your second part of the questions first. So when we talk about age gating, just let me clarify what age gating and age rating are, correct? Age rating is the graded process of moderating content and saying, having content descriptors like ESRB. Right now, it is not legally mandated for us to follow anything, but because of Google Play Store, Apple Store, etc., automatically there's something called an ARC which follows ESRB, PEGI, etc., correct? So we don't have anything legally mandated. But when we talk about age gating, and I think these rules will only compel age gating. Age gating simply means that if you are under the age of 18, because you are playing a money game where money is involved, people only above the age of 18 can play, correct? So that's a very simple thing. One line has to be put in the framework. Anyone under the intermediaries, OGIs, should put in technical measures to ensure that anyone under the age of 18 cannot play these games. That's it. There's no common denominator there, correct? Obviously when it comes to content moderation, which is, it's not, because these rules are a part 2 of these rules. If it was under the publisher's rule, then that conversation would have come in. So I think that is something that the government will look into. So that's the second part. So in that sense, we are very clear. The second thing is about what will everyone run for the common denominator? And it's a fair question. It can happen, but how we are seeing it and what the conversation in the industry is, that the industry themselves went to the government saying, please regulate us, correct? And MeitY has obviously a right to sort of give directions, etc., to companies, etc. They have the right to de-recognize SROs as well, correct? So what will happen is that if there are a lot of pain points for players against the SRB, they will definitely go to MeitY, and MeitY will be answerable. They also have to know that these rules are innovative, so they will have to balance that. So what I'm thinking is that the companies will act as a checks and balance against the SRB will act as a checks and balance against the company, and MeitY will act as a checks and balance against everyone. That's the hope, but as Rutuja said, let's see how it pans out.
Does anyone have a different perspective? Saloni, feel free to come in whenever you want, but Shana, you can go.
Yeah, just to speak to your question on the cartelization of standards, right? I think that's a real risk. And that's also what I believe is likely to happen in the short term. It is going to lead to some sort of arbitrage across SRBs. But I think what's going to happen is that, and what the way I see it is that MeitY has left a lot to market forces and to softer checks and balances, right? They have not been prescriptive to the extent of saying that here is a methodology that every SRB has to follow. So they're not creating the uniform kind of methodology. But they have retained the ability to give notice to the SRBs, right? So it's not as though, if they believe that the SRB is not catering to a higher standard of compliance or not asking their members to comply to that, they will just automatically deregister them. MeitY does have the ability to issue instructions to the SRB as well. And what is going to happen over time is that those instructions, hopefully MeitY will make them publicly available, will serve as a body of, the minimum standards that SRBs will have to comply with over time. There's also nothing preventing MeitY from saying that, listen, we will issue model charter documents the way they've done for online publishers. And so we're going to see a lot of these softer measures come in place to act as checks and balances for exactly the kind of problems that you are saying. And these are problems that I would argue that a lot of markets that have, or a lot of sectors that rely on certification have, right? And I think MeitY has taken a very deliberate decision that, listen, we are not going to get into this game of setting up a BIS type of an institution that is going to do this onerous licensing certification process. We are going to listen to what industry has to say right now, which has been that allow us to set up that self-regulatory mechanism, right? If it doesn't work, like Dhruv said at the beginning, I agree that MeitY has not been shy from amending frameworks if they believe that a existing regulatory mechanism is not working. But I think even beyond that, to the risk of allowing members to comply at the lowest common denominator of compliance, the immediate check to that is that the law itself has a floor requirement, right, so to speak, of what are your diligence requirements. The SRBs have to ensure that the members are at least complying with that before they're even admitted as members. And then I think there's also something to be said about having that flexibility to say that, again, risk-based flexibility, to say that, listen, this particular format of game perhaps does not pose the risk that other games like Blue Whale does. And so yes, there is a risk that we may be, there may be appetite towards catering to the lowest common denominator of compliance, but even that lowest common denominator has been set by law. You can't go below that, right? And then again, it is in that self-interest, it is in the self-interest of the SRB to show that they are, they do have that robust mechanism, they are promoting better compliance culture amongst their members and sectors. So it's going to be a lot of these softer issues that are going to act as checks and balances, and not kind of prescriptive mechanisms in the law, which we've seen MeitY and other departments, other ministries in the government actively stay away from when they're engaging in lawmaking now.
Just to add to what Shahana said, and she's right, the bare minimum can anyways be prescribed. But I think there's a lens of practicality that so any solution that you come up with is going to have issues, right? If the government were to license everything, it'll become a license raj. There'll be bottlenecks to when things get approved. There could be capture at that end as well. So the question is that what is the better of the sort of bad frameworks, maybe, so to speak. This is not necessarily bad, but that's probably the lens to see that everything is going to have some issues. The question is, can you pick one that has the least issues? Let me take one last question. Is there anybody? Yes, in the middle table, yeah. And then after that, we can always continue the conversation over lunch.
Hi, I'm Riddhi Gupta. I am a LAMP fellow. My question is regarding these games that are hosted on e-commerce platforms. So some of them have an element of chance, others are skill-based as well. They can be quizzes of sorts. And they do have the tendency to, influence consumer behavior as well. So are those within the contemplation of these rules or IT rules in general?
Does anyone want to take that? Games on e-commerce platforms.
Is that what you're referring to? For instance.
Sorry, can you switch on a mic? Yeah. It's on. Good.
Yeah. No, so could you repeat the question in terms of, give an example of what kind of platform you're referring to?
Yes, for example, Amazon, if you are on the app, there are these lucky draws that take place, or you can have those daily quizzes, and then you could perhaps win an iPhone. You could even trade some points that you've earned on your purchase to play these games, and then earn more points, or maybe enter a contest. So they can turn into addiction, and it can also, the idea is to make you hover on the app for a longer period of time. So are those games also within the contemplation of these rules, or any other rules for that matter?
Sure, thanks for that. Please chip in. But I think my understanding of the definition of online games that the rules talk of is wide. It talks of anybody who can offer online game, and where you put in a deposit or you've put in money to play the game. And I think you could also look at, and they talk of deposit to be in cash or in kind. So if you're looking at the kind option to be your coins, with which you can, level up in the game or have another quiz to play, then that's potentially it'll come under the regulation of what these rules prescribe. But feel free to chime in.
Yeah, I think one of the critical elements here is that technically I'm not paying a deposit to be able to participate in that quiz. But the counter argument to that is that I would have had to make a purchase of a certain value for that quiz to become available to me, which happens on some of these e-commerce platforms. But then there are other formats which I can just go onto the platform and pay. Like even if I haven't made any purchases, those games are available for me to play, which are free to play games, right? So I think it'll come down to what exactly are the features of the game and at what point are they offered, uh, and to what extent can I say that there is a deposit and there is a winning that I can expect after playing that game. So I think it'll come down to those sorts of facts and analysis. But it's entirely possible that some of these games that are offered, even if it is on an e-commerce platform, would be subject to these requirements. Dhruv, unless you have a
No, I agree with Shan and Rutuja that basically the rules, in very simple terms, says that deposit in cash or kind and winnings in cash and kind, but winnings has to be based on the performance of the player, correct? So that's also a relevant point, that it has to be, the winnings has to be on the basis, distributed on the basis of performance of the player, correct? So, and also those games can't be purely games of chance because they will run afoul of betting and gambling laws. So that narrows the universe of games that are sort of can qualify. But again, as you said, Amazon. So let's say they have a spin wheel concept, correct? But in that, you see, you just get, because you just get monthly thing where you can spin. That won't. But if they're coins which are worth money, then yes.
Also, one other item I think would be the exposure, the extent of exposure to harm for that user, right? I mean, there is only so much you can play in quizzes on Amazon, as opposed to other gaming platforms where the fundamental offering is to play a game or to play quiz. So I think that will also be a part of the consideration when they see whether they should be regulated or not.
Great. With that, let's give a very big round of applause to the panel. Uh, Thank you so much, everyone, for taking the time. I know this has been a long-standing ask of the gaming industry, and this is a step in that direction. Obviously, there are some issues potentially that need more digging, but largely it seems to be a step in the right direction, and eventually, hopefully, we'll see more developments on the legislative front. And as MeitY is looking for feedback till the 17th, at least for now, I think I would urge everyone here to, as you're writing, keep some of these perspectives in mind that have come up here today, and hopefully it will lead to a better version of the rules that come up later. But with that, thank you so much, everyone, and thank you, Saloni, for joining us online. And let's break for lunch. Thank you.